Good afternoon, colleagues, ladies and gentlemen. First of all, I wanted to start off by reminding my colleagues and the rest of everyone here that we're pursuant to the order of reference on Thursday, April 14th, 2016, and Section 20 of the Freezing Assets Corrupt Foreign Officials Act statutory review of the Act. We will begin this review this afternoon by hearing from some officials of the Government of Canada. And we're going to start off this afternoon with Global Affairs Canada and Hugh Adsett, the Director General Legal Affairs and Deputy Legal Advisor, and Marc-Yves Bertin, who's the Director General International Economic Policy. And if Mark's phone goes off, we're going to shut her down and let him answer it, because he's got more important things to do than us. His daughter might need him. So, and I say that seriously, because that's something we just agreed to, Mark? So, I wanted to remind everyone that that this is also a part of the Special Economic Measures Act and a number of other acts relating to this piece of legislation called the Freezing Assets of Corrupt Foreign Officials Act. And just so for those who are sort of following this, this is a section in the Act that deals with an automatic review after 5 years. And so the intent of the committee is to do its legal work based on the aspects of that legislation, and then to report and recommend back to Parliament, and in so doing, the Minister and the Department as to what we think of the legislation and how it's working in the context of today. So with that, I'm going to turn it over to Marc-Yves Bertin, who is going to do a joint presentation. So colleagues, this will be the first hour and this will be a joint presentation, and we'll go for an hour with questions, and then we will then proceed with the Royal Canadian Mounted Police and the Office of the Superintendent of Financial Institutions. So with that said, I'll turn it over to you, Mark.
Thank you, Mr. Chair. Perhaps first off, I'd like to say that my colleague and I, Hugh Adsett, and I are delighted to be here to support the committee's work, particularly given our respective responsibilities over policy and operations under CIMA and FACFOA. But we recognize, however, that the committee is interested in issues of sanctions in a manner that is quite horizontal and may go in areas beyond areas of our responsibility, and may very well be interested in covering discussions around other statutes. So I'd simply like to reassure the committee that Global Affairs Canada, our department is willing and very much able to make officials available as your deliberations and work unfold. With that, let me say bon après-midi et merci au comité de nous recevoir.
Good afternoon. Thank you for welcoming us today. On behalf of Global Affairs Canada, I'd like to say that your review of the Special Economic Measures Act and the Freezing Assets of Corrupt Officials Act is coming exactly at the right time. In Canada, the government is reviewing its policies and programs so that international initiatives by Canada reflect world reality as it stands today. This requires policy reviews that have been highlighted in letters of mandate to ministers. Internationally, conflicts have a great impact, like the Syrian war, which is extending into Europe, and areas like North Korea threaten world security and stability. Against that backdrop, reviewing our legislative instruments is an important measure. The text of the Special Economic Measures Act was tabled in 1992 in order to improve Canada's ability to join other states promptly and effectively in applying economic sanctions. This was done in the context of the increasing trend by the international community to use economic sanctions as a means of maintaining international peace and security while reducing the recourse to military force. The CIMA allows Canada to adopt regulations to restrict or control the activities of Canadians and persons in Canada by prohibiting their engagement in what would otherwise be lawful business or economic activities to and from a foreign state or listed persons of that state. The Act specifically allows Canada to impose economic sanctions through regulations in two situations. First, when an international organization or association to which Canada belongs calls on its members to take economic measures against a foreign state. Second, when a grave breach of international peace and security has occurred that has resulted or is likely to result in a serious international crisis. Asset freezes are one of the targeted tools available for imposition once one of the CIMA triggers has been met. The determination of individuals and entities to designate for asset freezes is usually done in coordination with like-minded countries. In the case of CIMA, Canada typically imposes sanctions to complement existing UN-mandated sanctions, such as those of Iran and North Korea, or when the UN Security Council is unable to reach consensus, as in the case of sanctions against Russia for its actions in Crimea. Canada's use of CIMA-imposed sanctions has increased over the past decade, growing from one regime in 2007 to 9 in 2016. Currently, Canada has sanctions imposed under the CIMA against 9 countries: Burma, Iran, Libya, North Korea, Russia, South Sudan, Syria, Ukraine, and Zimbabwe.
First note that it was enacted in 2011 in response to the Arab Spring events. Accordingly, it provides a responsive tool for Canada to support a foreign state that is in political turmoil and seeks to transition towards democratic rule and governance. The FACFOA authorizes the Governor and Council to temporarily freeze the assets of allegedly corrupt officials, foreign officials that is, at the request of a foreign state, to allow this foreign state the opportunity to seek the ultimate seizure and recovery of assets through mutual legal assistance frameworks. Canada currently has regulations freezing the assets of politically exposed persons in relation to Ukraine and Tunisia. In closing, I would note that while FACFOA is utilized on behalf of a foreign state, the CIMA authorizes the Governor and Council to take action against a foreign state. In this respect, FACFOA sits apart from Canada's sanctions regime. With these considerations in mind, my colleague and I look forward to your questions. Merci.
Okay, thank you. And we're going to go right to Mr. Kent, please.
Thank you, and thank you, gentlemen, for joining us here today. As my first question, I'd like to ask, is there any legislation in place today which would allow Canada to ban the visas of individuals about whom credible evidence exists with regards to human rights abuse or corruption abroad, and their attempts to bring that money to Canada?
Thank you, Chair, and thank you for that question. I think that question is a question of admissibility to Canada. It's a question I think that's probably better answered by colleagues from IRCC, from Immigration, Refugee and Citizenship Canada. I suspect it's linked to their legislation.
Well, the reason I ask that question is the case of Vitaly Malkin, with whom I assume you're familiar. Vitaly Malkin, who for 20 years tried to gain entry in Canada, tried to gain citizenship in Canada, who was prohibited, he was associated with money laundering, arms trafficking, trading in conflict diamonds, embezzling United Nations aid monies, using profits from organized crime, there were allegations, to subvert the democratic process in Russia, interviewed by CSIS, banned by officers of Canada Immigration, a prohibition which was overturned by an Ontario judge on a definition of Russian entrepreneurship in Canada. I'm just wondering, would CIMA or the Corrupt Foreign Officials Act have any effect on prohibiting an individual like Mr. Malkin from entering Canada, bringing wealth to Canada, becoming a citizen of Canada?
Thank you. I can say that neither SEMA or FACFOA address questions of admissibility in their legislation. So there are provisions in the Immigration and Refugee Protection Act that deal with admissibility, but there's nothing in the Special Economic Measures Act that deals with questions of admissibility.
Would Foreign Affairs, and I understand I'm getting into a sensitive area here, but would Foreign Affairs be aware of the reported 21 lines of secret information that the federal judge, in overturning the immigration ban, ruled too sensitive to be released to the public?
I'm not.
Sorry, I mean, the short answer, if that's your answer, is we're not aware. But I think it would be, it'd be inappropriate to offer a view for a number of reasons, including the sensitivities that I think you're alluding to in the way that you've posed your question. Not least of which, though, is because IRPA is the responsibility of another department, another minister.
I understand. In the absence of what Parliament last year voted unanimously for in the form of the Magnitsky Act. But I'm just wondering, when the minister appeared before us and in other venues, he has expressed opposition to the Magnitsky Act on the grounds that it would interfere with Canada's relationship with Russia on the Arctic Council. And I'm just wondering whether you see any possible or potential conflict that would arise should Parliament, in its wisdom, pass the Magnitsky Act in the coming months.
I think, thank you for this question. Very much recognize that the Magnitsky case and potential legislative approaches to responding to that is an issue of interest to this committee. Recognize, of course, as well that there are a few bills in play, both the previous session and in this session, which will provide a good opportunity to debate and consider the merits of these statutes. The work of this committee as well is going to be interesting and important, and we'll follow with interest insofar as there will be no doubt a lot of discussion of this issue over the weeks and months as your work program unfolds. As part of our own examination of SEMA and FACFOA, of course, we'll be looking at the discussions and the public debates around these issues as we formulate our own view. As such, at this time, I think it would be premature for us to offer a government position on something that is still under consideration.
With regards to FACFOA and the point that you made in your opening remarks, many people see FACFOA's shortcoming with regards to the temporary freeze on the assets of allegedly corrupt foreign officials, and the fact that the SEMA would not be capable of blocking an individual that I described earlier trying to bring funds acquired through corruption and abuse of human rights abroad, placing those funds in Canadian banking, financial institutions, or real estate.
I think
your comments.
Yeah, I think Hugh will probably Hugh will have some views on this, but I may add some at the end.
Okay, well, I will be brief because you've correctly, I think, pointed to the provision in the Freezing Assets of Corrupt Foreign Officials Act that does make the duration of an order under that act temporary. It's for 5 years. Those orders can be renewed if a foreign state requests that the order be renewed or the regulation be renewed. So it is a 5-year limitation, but it can be renewed, and that renewal can be for more than one period of time if the foreign state requests that. Mark, maybe you wanted to add more.
Sure. Just perhaps on the issue of on the points you made about SEMA and our inability to deal with individuals who might be coming in. I guess what I would note, without speaking to the powers that the government would have under another statute such as IRPA, what I would note is that it's important to remember that a number of the actions that we take under various statutes are actually governor and council decisions, which by their very nature implicate a collective decision-making process, multiple ministers around the table. That means that departments actually have to work together and coordinate, both to support these types of decisions, but in doing so, ensuring a whole of government coherence to the way that they're looking at what it is they may be considering under various policy and operational contexts under their own statutes. So the issue, I think, at the core of your question is, do we have a bit of a gap of coordination and coherence because of the statutes? You'll know better than I that in our Westminster model of government, ministerial accountability and collective accountability of the cabinet process is an interesting sort of dynamic. But it doesn't take away from individual minister responsibilities and accountabilities under statutes before Parliament, and therefore we have to work within those constructs. The construct or the solution to that challenge inherently is interdepartmental collaboration.
Thank you, Mr. Kent. I'll go to Mr. Vagascatos, please.
Thank you very much, Chair. Thank you for coming to the committee to appear today. In your remarks, you mentioned that sanctions have always been seen as an alternative to military force. With that in mind, I wonder if you could tell the committee, in your view, how effective are sanctions as a tool in achieving a restoration of international peace and security, democracy promotion, human rights protection, counterterrorism, and many other laudable goals that we'd like to see in the international domain.
Thank you for that question. I think, I guess first and foremost, yes, we do see sanctions as an exceptional tool because of the restrictions that we are inherently applying to what are otherwise completely legal activities, as well as because of the risks associated with the use of sanctions. But the way that the way that we look at their effectiveness is an interesting one insofar as effectiveness in terms of pursuing or persuading a change of behavior and policy shift is a very difficult thing to attribute results for in an international context. Sanctions are a complementary instrument. We use them generally when other mechanisms or other steps that have been taken and tried have failed. And because we do that as part of a broader suite of interventions, whether that's negotiations, participation in peace processes, or international advocacy activities, it's difficult to know what was the tipping point, right? What complicates it even further, please?
No, go ahead.
I would say what complicates it even further is that we tend to use this instrument importantly along with other countries. So we harmonize our approach with other countries, which means that the relative weight of Canada's intervention versus the relative weight of the European Union or the United States or what have you is difficult to discern in that context. That said, we tend to view them, as I was mentioning, most effective when they are a complement, a selective complement, linked to a clear policy outcome or desired shift in policy and behavior on the part of a foreign country, when they're applied universally, as well as when they're tailored or smart, to use our internal jargon, insofar as they're focused on key decision makers and their associates.
Well, you've avoided a lot of jargon today, so on behalf of the committee, I think I can say thank you. Question as far as CIMA goes specifically. Obviously, when an international organization, the UN, for example, issues a determination under Chapter 7, for instance, that grave breach of international peace and security has taken place, and it's clear that that determination has been made and Canada can act in kind. But I'm more interested in the second aspect here. When a grave breach of international peace and security has occurred that has resulted or is likely to result in serious international crisis, but no, it is not clear that an international organization has deemed it in that way. But Canada still, under CIMA, has the power to impose sanctions. Who determines how international peace and security is defined in that instance, and how is that defined? So who does the determination, and how is that defined exactly?
Thank you very much for the question. It's a decision at the end of the day for the Governor and Council. The Governor and Council makes the determination under the Act as to whether there has been a grave breach in the view of the Governor and Council. Grave breach isn't defined in the Act itself. It really is a question of the context. Advice will be given to ministers, and ministers will, of course, then take that into consideration and make the determination and a recommendation to the Governor and Council. That's both the process and, in a way, that's the substance too.
So you say there's no clear definition in the Act. Do you think that is problematic, or is that something that shouldn't be of concern?
I won't venture an opinion because I think that'd be really for the committee's views and for ministers to speak to. I would say that my recollection from having looked at the parliamentary record at the time that the Act was adopted was that there was a debate at the time about various elements of the Act, and at the time part of the conclusion of the debate seemed to have been that there was benefit to having a broad scope for possible action to allow the Governor and Council to make essentially to make decisions in very fluid contexts where there may be a number of things that are at stake.
Okay, last question. Is it possible, with everything that you've said, is it possible that human rights violations could fall under a definition of a grave breach of international peace and security? Could they be captured under that category?
Without and I should perhaps put a caveat on what I say as well, because one of my roles is to provide legal advice as well in the department. So without providing legal advice at all, but certainly there have been situations where there have been serious violations of human rights which have formed part of the conclusion that there was a grave breach of international peace and security such to cause an international crisis.
I still have, yeah? Okay, great. And that would include abuses perpetrated against whistleblowers, for example. Given that those kinds of violations usually take place within a context of mass human rights violations in general.
It goes back to essentially what the test is in the legislation itself. So it could be human rights abuses, it could be violations of international humanitarian law, it could be a number of different elements that might allow you to reach that point of being a grave breach of international peace and security. I wouldn't want to say that there's any one specific element that will necessarily trigger that, whether it's your example of abuses against whistleblowers. It really depends on that entire context. It's very hard to take one specific aspect out.
Sure, thank you.
Thank you, Mr. Fergus-Carros. Madame Lavillière, s'il vous plaît.
Merci, Monsieur le Président, et merci.
Thank you, Mr. Chairman, and thank you to both of you for being here today. I think you should be tolerant because we are just beginning the study. I know that I'm trying to find my way through how everything works. My colleagues have asked some very interesting questions that I was going to put. But I'd like to come back to the question of sanction effectiveness. I think there's been a great deal of debate on that, and there is always the issue of, how can I put it, not harming a given country's population with sanctions that are imposed. Have there been any comprehensive studies? Has the UN done a comprehensive study on the effectiveness of sanctions, something that we could use in our discussions? Yes. I see Hugh nodding. There have been studies conducted, and they're very good analyses in the public domain, commissioned by academics, companies, or international organizations like the UN. I think that on the whole, what we can say is this. Research has shown varied conclusions. Conclusions, of course, depend on the databases used, the countries in question, the particular instance under study. And as I was saying earlier, the notion of effectiveness and of impact means that it's actually very difficult to target how sanctions have had an impact as opposed to the package of measures as a whole. As we deepen our learning of this domain, I'd like to understand who does what and what each party's responsibilities are. If you have information to give, it would be very welcome. I'd also like more specific information on the freezing of assets and the seizure of assets. I'm thinking of Ben Ali, for example, the Ben Ali case, the Tunisian, the brother-in-law of the Tunisian president who took refuge in Canada. His assets had been seized, and Tunisia asked for them to be returned to the country. But I believe that only a very small fraction of the assets were returned. How does that process work? Well, we can begin with roles and responsibilities. I'll do that, and then Hugh will talk about freezing assets. Our role, I can give you a broad outline of who does what, or at least who we work with and how. Our role is to provide opinions and recommendations to foreign affairs ministers who, under the legislation, are responsible for making decisions and giving recommendations to Cabinet on what sanctions to be taken. We cooperate with finance department agencies. There are people here to talk to you about their role. We provide information to financial institutions, but it is our responsibility as a department. We have a statutory responsibility, in other words, to work under the Act and to apply the Act. We work with the RCMP and with the Canadian Border Services Agency on implementation of the Act on the enforcement side. Our role, of course, is to coordinate, and that has an international component because we work with other countries who have the same outlook as we do, at least with international organizations like the UN. We have an important role to play in the coordination aspect. We also work with the Department of Finance, of course, because, let's say, when we have to work on regulations, draft regulations, and guidelines for decision making. I'm going to stop there and let Hugh carry on. Thank you, and thank you for the questions. I'm going to answer in English.
Assets of Corrupt Foreign Officials Act, of course, does provide for asset freezes. And in the specific case of Tunisia, there were something in the order of 123 different individuals that were identified as politically exposed foreign persons whose assets could be frozen in Canada. I'm not in a position to be able to speak to specific individuals or specific cases. I would, though, note that under the Act, what happens is the assets are frozen. If the foreign state wishes to have the return of those assets, they need to take a further step to be able to have the assets returned. That's usually going to be in the nature of a mutual legal assistance request in order to have assets returned. So the Act itself, the Freezing Assets of Corrupt Foreign Officials Act, is, as was suggested, it's very much in the spirit of a temporary measure in a very particular set of circumstances to allow for that temporary freezing of assets.
Just to make it a little easier for the committee, one of the objectives of the exercise is to connect the dots vis-a-vis the machinery of government. Because as you know, there are a number of acts that are attached to the work that we're doing. And I think Madame Lavediere's question relates to a little more in-depth interest by the committee as to matters like export permits that are connected, matters that deal with the decision-making process through the Ordering Council, matters that relate to the United Nations Act, and why we would prefer to go use these pieces of legislation versus what's being recommended at the UN. And so there's a number of connecting pieces. And so if it's possible, try and inform the committee as much as you can about how the machinery operates to connect the dots. If you can't, and it needs someone else to be at the table, we would very much like you to sort of let us know that, because it's our intention to go through the exercise. And as you might imagine, at some point we will be going clause by clause through this legislation. And there are a number of pieces of this legislation we could ask you today, but it's a little early. Not to say that the committee won't do it, but it's the objective to sort of get a better understanding of that. For example, in this section dealing with freezing assets of Corrupt Foreign Officials Act, it talks about the fact that we are asked by another country to put this in place, and they would ask for it to continue after 5 years. I mean, the obvious question to that is, at what point do we do our own review and say, well, you know, may not be appropriate? And so those are the kinds of machinery or government issues that I think we want to make sure are in the legislation that the Government of Canada can deal with. So I just want to bring you back to that larger discussion that we need to have early on, and the machinery of government seems to be a big part of how we'll deal with this. Because again, I go back to this, the second part of what you may be not aware of. We are aware that some other countries like the U.S. Arrive at this decision from a different machinery of government structure. And we will be looking at how the U.S. does it and how Britain does it, just to see, to compare and contrast, to see whether theirs is more effective than ours, and that's part and parcel of the process. So just to give the witnesses a sense of what I think the committee is looking for. So that's enough from this member, and I'll go to Mr. Levitt.
Thank you. And actually, I'm going to forward on from there a little bit. How does the government coordinate and cooperate with like-minded states and international organizations in the design, application, and enforcement of sanction measures? And maybe you can use two examples, Myanmar and Russia, which are currently, quite active files for this committee and others.
Thank you very much. At a very high level, in a very broad sense, the government uses, particularly its diplomatic channels, its diplomatic missions, in order to coordinate our activities with like-minded states. And we actually do work on sanctions quite closely with like-minded partners, whether it's the United States, whether it's the European Union, Australia, others that we often work on a lot of international issues together with, and sanctions is one of those areas as well. So there are different networks depending on the specific sanctions regime, different groupings of diplomats who might come together in some manner to discuss sanctions, and those can unfold really depending on the circumstances. So that's I think probably one of our principal ways of coordinating is through our missions abroad. It's through our missions abroad and our diplomatic network.
And in terms of Russia and Myanmar, can you give us a little bit of an insight into how those sorts of sanctions would come about with our allies?
I mean, as Hugh was pointing out, I think we tend to work we tend to work in various offices, various points on the map, so to speak. If we're talking about a rapidly unfolding event that is the concern of the international community, there'll be a lot of attention paid to this in New York City. UN might, and our mission on the ground would work with other countries to identify and influence sort of the course of actions and how things are materializing. But once the UN Act, for example, and perhaps to tie the knot to what a question that the chair was pointing out, once the UN decides that there are going to be sanctions, if they can agree, well then we, under the UN Act, are compelled to do so, and then we implement. What we'll do at that point, because the discussions at the UN will tend to be of a sufficiently high level, and in terms of the breadth with which they'll identify the types of actions that should be taken, that is, we will work interdepartmentally to identify just what makes the most sense within a Canadian context in terms of the types of sanctions or the elements of the sanction that we'd like to pursue. At the same time, there may be instances where this, an area or an issue of concern isn't playing out at the UN because, for example, one of the Security Council members won't agree with the others. And so within that context, the conversation will be pursued in different venues. It could be in the Commonwealth, it can be in other such venues, and where the international community will come together. So there's a degree of like-mindedness that, often characterizes the way that we behave with others and how we behave amongst others, and that is trying to pursue a harmonized approach. And so invariably what that means is that it takes a degree of entrepreneurial spirit on the part of Canada's diplomatic corps and the diplomatic corps of other countries in the way that they'll make their arguments and positions brought forward. That is, the arguments and positions of their government.
And just in terms of a little bit of follow-up on that, obviously sanctions are dynamic in that things are changing within the countries that we're dealing with all the time. How often are our sanctions reviewed once they're in place? Using maybe Russia as an example, how are the lists of individuals and entities that are subject to the sanctions measured and derived, and how often are those kind of updated?
Yeah. I think sanctions, once applied, are monitored on an ongoing basis because they're part of a broader bilateral response. If we're talking, in terms of, sorry, let me define that. Insofar as the sanctions are often taken within the context of a number of other discussions and activities that are going on, we will, and our missions in particular, play a frontline role in terms of assessing just how things are being met and the implications on the ground. So they'll get feedback from the public, including, for example, the private sector who might be interested in, or who might have views in terms of trying to do business in a given context or market. So we do that, and we do that on an ongoing basis. Now, that said, the Act, CIMA, actually has under its administration and enforcement section a requirement for the Governing Council to issue a report within 60 days of the lifting of a regulatory measure, i.e. sanctions. Once they're fully lifted, we'll issue a report, or we have to issue a report. Thus far, we've applied CIMA in 11 instances. Twice that has been lifted completely, so Haiti and Yugoslavia, and under both instances, we've issued a report within the 60 days. So there's tactical and then there's strategic, if you will.
You got it one time.
One more minute. Back to FACFOA for a second, or onto FACFOA for a second. You mentioned Ukraine and Tunisia. Have any requests from foreign states requesting sanctions under FACFOA been denied?
I'm not aware of any having been denied.
Okay, thank you very much, Mr. Levitt. Just on that matter, Canada's regulations for the freezing of the assets, you said something in your comments of some 200 have been applied at one point, is that right?
Sorry?
How many of the regulations, or how many people have been, politically exposed persons have been put on the list? And how many put on the list versus how many are right at this moment still in effect?
Thank you for the question. I'm just going to look at my own notes. It's we had adopted regulations under the Freezing Assets of Corrupt Foreign Officials Act in the cases of Tunisia, Egypt, and Ukraine. The total number of listed persons was 289, and currently there are 8 individuals listed under Tunisia and 18 under Ukraine. That's the current numbers.
So 8 and 18.
That's correct.
Okay, out of the original 289.
That's correct. Originally it was 123 for Tunisia, 148 for Egypt, and 18 for Ukraine.
Okay. Before I go to Mr. Miller, I just want a question that may not get an answer right off the bat from the table, but I want you to think about it. We are very interested in having a conversation more than just hypothetical. And it's my interest as the chair in making sure the committee is well informed. So I'd want to ask Global Affairs for whether they be allowed, you would be allowed to come in camera and to have a discussion just with the committee if necessary, so we could talk about specifics in order to get a better sense of how this all works. And the only way to do that, of course, would be in camera. And so I'd be interested in your views of that, not necessarily at this moment, but I'd like you to get back to the committee with that particular request, if that's possible. And with that, I'll go to Mr. Miller. Thank you.
Thank you, gentlemen. As Bob alluded to earlier, we're beginning an extensive review of these two legislative regimes and their related or connected acts. And part of the exercise is to figure out actually what they do, what they don't do, what they should do, and what is desirable for this committee to recommend if there are holes. They are complicated. They're intertwined. Obviously, what has been on the top of our minds in light of the testimony that's been given in prior meetings of this committee is the topic of gross violation of human rights, regardless of the country or officials perpetrating them. So the question really is, when you examine the legal regimes that exist in Canada, is there anything that addresses the ability of the government to freeze assets in the presence of a gross violation of human rights by a foreign official or a foreign person, in the absence of terrorism, because that would not fall under Section 83 of the Criminal Code, the proceeds not being that of crime, literally it's assets of a person in Canada, and then in the manifest presence of gross violation of international human rights as assessed by some standard, which we don't need to go into at this point, that does not rise to a violation or a grave concern for international peace and security. So in my mind, that sort of scenario takes us out of CIMA. It takes us out of a requesting country under the FACA, whatever the acronym, FACFOA is. In my mind, there's a void there, but you're the experts, I would like you to speak to that.
Maybe I can just give a very factual answer to the question. And I just took notes to make sure I had the paradigm that you have in mind down correctly. But essentially, you're talking about a situation where, although there are gross violations of human rights, it doesn't rise to the threshold of a grave breach of international peace and security. And you're talking specifically about freezing assets as opposed to admissibility questions, for example. So situations where an individual may not be admissible to Canada because of the application of the Immigration and Refugee Protection Act. I'm not aware of an existing legislative instrument that has those specific criteria. As I was saying with the Special Economic Measures Act, there are a couple of what we call triggers, but the trigger for our own autonomous sanctions is the grave breach of international peace and security. That might be in a situation where there are gross violations of international human rights, but that is not the term itself that's used in the Act. The other potential vehicle that exists would be if the Security Council was to make a decision in that context, and then we would have to implement sanctions in that context.
Okay, so follow-up question to that. Is there anything that prevents the government from just doing it with respect to foreign nationals and their assets situated in Canada, other than investment treaty protections?
Sorry, can you perhaps...
Can the government just freeze assets of a foreigner situated in Canada?
That's, I think, a question that probably goes beyond my competence, in the sense that I'm going to say that I'm not aware of an ability of the government simply to freeze assets. It would need a legislative basis of some kind, but I can't speak with any definitiveness on whether there are other instruments out there, what the full range of instruments might be.
So, and then I guess final question, observation, far be it for Canada to act in a unilateral way in such a sensitive situation, because the situation I'm describing is really one where it would be readily ascertainable by a large part of the international community that, as you mentioned, or at least alluded to earlier, you would prefer to act in concert with in imposing sanctions. And the question then that I believe is raised is, if there's a hole of the nature that I described that needs to be filled, what are the what are the pitfalls internationally with respect to countermeasures that a country that may be stronger than us or weaker than us may enact against our foreign nationals, against our nationals, which would be obviously foreign to them, and then what measures could be taken on a trade level against Canada should it choose a path that would be truly unilateral as opposed to working with its multilateral partners. Glad if you would like to comment on that. If it's outside the ambit of your presentation, fine.
Thank you for that. Thank you for that question. I think just with respect to sanctions in general, whether unilateral or not, they always entail some obvious consequences, both for the target state and targeted individuals, but also for the sanctioning state. This includes loss of commerce. Adversity can affect civilians, including lost jobs and economic hardship. And with respect to the imposing country, that is the country that's sanctioning, the same is also true insofar as business opportunities for firms can be lost. In fact, if countries institute import substitution programs, the economic implications can be lasting. There are also implications for citizens in terms of wanting to send remittances, for example, to a targeted state. And you always expose yourself to retaliation by the target state and their allies. So you do something, they'll do something back. So that's why we look at these sanctions as an exceptional measure. And that's why we tend to use them, that's why we've always used them in a harmonized manner with other countries, as well as in combination with other measures, diplomatic measures. But what we do, if I may, what we do tend to do is, and there's been a bit of an evolution in international practice since CIMA was first instituted, is that we've gone towards more targeted measures, that is going after and targeting decision makers and their associates. For the simple reason that, in many respects, there is a concern that the early days of sanctions practice, broad-based embargoes, actually had that negative impact on populations. The interesting thing about a more tailored approach, at least the economic theory goes, is that by taking a targeted approach, what you end up doing is mitigating the implications for third parties, so other countries and their citizens and entities or private sector players. And that has the virtue, in theory, of reducing and mitigating the desire to defy a sanctions regime. So all that to say is there are obvious implications with sanctions, whether unilateral or multilateral, and we always have to be prudent in the way that we look at that.
Thank you very much. I'll now go to Mr. Kermish, please.
Thank you, gentlemen, for coming in today for the beginning of this study. So I'm going to begin with the Special Economic Measures Act. So my first question to you is going to be the grave breach of international peace and security. How is that defined by your department right now? I understand there's a definition that's purely up to the government to decide, but what is the definition the department is using right now?
I'm not sure that my answer is going to be entirely satisfactory in the sense that the practice is to look at the context. It's to look at the facts of the situation and determine if in the view of those who are analyzing the situation that it seems to be one that would be a grave breach of international peace and security. I think that's probably about all I can say about it.
So do you rely on international institutions, or do you rely on internal analysts who say this situation is a breach and then you bring it up to the level of the government?
We would always look at what is the analysis of the situation, not only by our own diplomatic missions, but also by other international organizations, whether it's the United Nations, the Organization for Security and Cooperation in Europe, if it's an event taking place in Europe, the Organization of American States. So that kind of reporting that the department receives from its missions abroad, from multilateral institutions, public reporting and otherwise, that would all form part of the analysis of the situation.
Okay. So to change pace here, the Freezing Assets of Corrupt Foreign Officials Act, you had mentioned that no request has been denied so far, but are there any requests pending that have just not been dealt with yet?
Not that I'm aware of.
Okay. Maybe speaking more broadly then, how many countries does Canada currently have broad-based state sanctions put on?
just give me one moment, and I'll just make sure I give you the correct number, because I think I have that number. Maybe you've got it.
SEMA? Under SEMA, we've used it 11 times, and there are currently, or we've applied the statute against 11 countries, and currently there are 9 active regimes. That's right.
And beyond SEMA?
I was just looking at my notes to see if I had broken this down into SEMA and United Nations Act, because of course there's UN sanctions as well. I might have to get back to you with this precise number. I just want to make sure. It's not hard information, but I just want to give you the right number. There's a number of others. I'll see if I can find it in my notes.
Okay, so and how many of those, I guess this might be something you might get back to the committee on, and how many of those situations do the state sanctions then become very specific to organizations or actors within national governments which are taking actions that are a grave breach of international peace and security, or would fall under the Freezing Assets of Corrupt Foreign Officials Act? Because it seems like when you're targeting a national government, there's individuals making those decisions within there. So I'm just trying to get to how many of those then are also being targeted as part of state sanctions potentially, as opposed to individualized seizure of their assets, prohibition from travel.
Yes, I think Mark, Eve and I were just having a quick exchange here. I think it's in all situations that would be the case.
In all situations. Can you go back to the committee on the details on it, just so we can have that information for the future study? So, the state sanctions that we levy against different governments and administrations have these individuals then. But it seems to me like if we're punishing them for taking certain actions we disagree with, shouldn't we also be barring them from entering the country, doing business with Canadian companies? Like, that does not go part and parcel with sanctioning them without affecting third parties or other states that might do business with them that we may be allies with or on friendly terms with?
Go ahead.
Yeah. Look, I guess what we have to, and it goes back to a previous question. We obviously have to work within the legal institutional construct, which is our Government of Canada, and the way that ministerial responsibilities are attributed and the space within which they operate. So we have an immigration minister who deals with admissibility issues. We have a foreign minister who deals with matters under SEMA. I think it's fair to say that when looking at a case, a situation in our bilateral relationship with a country X, and we are of the view that something, something that's going on is inconsistent with our foreign policy objectives, broadly speaking. There are a number of things that we can bring to the table in terms of, there are a number of cards we can play. So sanctions would be one of them. Sanctions, generally speaking, is not necessarily a legal term. Just in general terms, sanctions can relate to limitations on travel, limitations on import and export of goods or technical data, as under SEMA. It could involve the imposition of asset freezes, financial services being denied, but also even restrictions and prohibitions in terms of transport, marine and air transport. So you've got a number of things that you could be doing in which you may elect to pursue at a given time, and as the situation evolves, you might decide that you want to ratchet things up or ratchet things down, both in terms of the types of sanctions that you can take, but also in terms of other types of activities that you may want to pursue, whether that's whether that's diplomacy and advocacy on the international stage, whether that's even programmatic. So there might be something that from a technical assistance perspective we might do in a foreign country in order to buttress or promote human rights or another public policy objective. So there are a number of instruments, whether it's legislative, programmatic, or just operational in terms of advocacy, that you can deploy. And so when looking at a bilateral relationship, our geographic desks have the lead to balance out all of these considerations in terms of where do they want to and where does the government want us to bring the relationship, and therefore they have to make a calculation as to which instrument they want to deploy and when.
Mr. Sani, please.
Thank you very much. One of the questions I have for you, and this is more hypothetical, just out of curiosity. Let's say you have one country and there's a change in government, either peaceful or non-peaceful. And some of the criteria that you've noticed here, that there has to be inner turmoil in that country, that the political situation is uncertain. How do we determine, or how do we decide that the country that's requesting us to make an order to disclose information, how do we decide whether that is not retribution for an entity, a political entity, whether it be a dictatorship or a democracy? How do we know that it's not retribution that's being asked of us, that it's a legitimate question?
Thank you for the question. It's an important question, and I think what I can say is that every time that there is a request under the Freezing Asset of Corrupt Foreign Officials Act, there is an analysis that is done, and a number of considerations would be taken into account. It's also possible under the Act for the Governor and Council to determine not to impose a regulation if it's viewed to be inappropriate to do so. There is an analysis that is done, as I say, varying elements, varying factors whenever there's a request that's made under the Act.
If you have an individual who's under the Freezing Assets Act and you're going to freeze their assets here, one of the things that we've seen, especially in international finance, is that person may have cloaked their investments in the country either through a corporation or through maybe someone else's name. What resources do we have to make sure that we have the ability to search and to know exactly what assets they actually do have in this country?
I'm wondering if perhaps I can wait on the question of resources because I think the question there perhaps may relate to activities of the Office of the Superintendent of Financial Institutions.
Okay.
Thank you. I just got a couple matters, and first I want to advise the officials that very likely you'll be called back, as you might imagine. This was a fairly quick and beginning of a process. I want to remind you of what I call connecting the dots when it comes to machinery of government. It's extremely important. One of the issues that I know is going to be talked about significantly in this committee is the multilateral significance of these pieces of legislation. Meaning, if you look at CIMA and the 9 sanctions that are still in place, I think one of the questions I'll be interested in having you answer at some point is, were these taken independently, or were we following the lead of other countries who had already put sanctions in before Canada put its sanctions in? And are there any on the list at all that were done independently of other nations, or are these all connected multilaterally? And that the review was based on information of other countries who are making these kinds of decisions as well. I think that's important to know and to keep in mind. The other issue that we will be again exploring is a way of being able to look at the difference of for example, I don't imagine the economic sanctions in Burma are the same as the economic sanctions of the other 8. There's a fairly broad context of how you arrive at economic sanctions, and I wondered if you could categorize them for us. Meaning there might be simple sanctions for certain countries and much more complex and elaborate, especially on the financial side, for countries like Russia, Ukraine, and then potentially even Iran. So I wanted to sort of get those differences because I think they make the discussion flow a little simpler, I think, if we could do that. So on behalf of the committee, I just want to give you the chance to say the last few words, and then we'll go on to our next witnesses. And I want to thank you for this opportunity to begin the dialogue, and I want to stress begin the dialogue. So unless there's further comments by our witnesses, Mr. Adsett.
Mr. Chair, thank you for that. I only wish to give the response to the question that I was asked earlier, which is the number of United Nations Act regulations. There are 16 United Nations Act regulations. I apologize for not having that at hand, but that's the information.
Okay. Thank you very much. We'll take a 5-minute break and then we'll get to our next witnesses. Seconds and we'll get back to committee work. Thank you, colleagues. We're now into the second hour of the reference that was referred to earlier on Section 20 of the Freezing Assets to Corrupt Foreign Officials Act and our statutory review of the Act. And so in the second hour, we're going to hear from the Royal Canadian Mounted Police and Superintendent Steve Nordstrom, Director of Federal Policing, Criminal Operations, National Security, and Sergeant Peter Hart, Federal Policing, Criminal Operations, and the Office of the Superintendent of Financial Institutions, Christine Ring, the Managing Director. So welcome to you all. And I understand there are two presentations. I'm not sure who's starting first.
We can arm wrestle. We'll start.
Okay, so the RCMP will start first. You have the floor, Mr. Nordstrom.
Good afternoon, and thank you for your time today, ladies and gentlemen. As introduced, my name is Superintendent Steve Nordstrom. I'm with the Royal Canadian Mounted Police. Je vous parlerai en anglais prédominamment.
I will be speaking primarily in English because my French is very rusty.
Okay. With an overview of the RCMP's role in relation to CIMA and the Freezing Assets of Corrupt Foreign Officials Act, FACFOA, that we'll use an acronym from now on. I'm also going to share some examples of a couple of investigations that were successful pursuant to those acts, and then briefly address some of the challenges that we face, not just within the investigation and prosecution of these acts, but writ large in the criminal justice area. The RCMP's mandate is a multifaceted one and includes preventing and investigating crime, maintaining peace and order, enforcing laws, and providing vital operational support services to Canadian other law enforcement agencies and abroad. While the RCMP leads national security enforcement efforts, we can't do that without our partners, provincially, regionally, municipally, and at the city level. We refer to them as cooperative ventures. The RCMP also works in partnership with other federal government departments and agencies, predominantly in this area that we're going to discuss today, such as the Canadian Security Intelligence Service, the CBSA, Global Affairs Canada, Immigration, Refugee, Citizenship Canada, and FINTRAC. We also work with international law enforcement and industry, both from here and abroad via our liaison officers. And we work within the Export and Import Permits Act as well. With CBSA, we work to address inbound and outbound breaches of sanctions and regulations at ports of entry and identify travelers who are ineligible for entry into Canada pursuant to the Immigration and Refugee Protection Act, or IRPA. The RCMP also has a shared responsibility with the CBSA to investigate cases linked to proliferation of strategic goods and technology. In terms of FACFOA, the RCMP receives information from banks and other financial institutions reporting that they have blocked all financial services to someone subject to the Act or its regulations. Financial institutions are also regularly mandated to search their records and inform the RCMP if they freeze assets and if they identify prohibited financial transactions pursuant to FACFOA. While the RCMP's role with respect to sanctions has included enforcement and investigations, we also provide training, participate in industry outreach activities, and contribute to general policy development as it relates to sanctions and counterproliferation. Any individual, company, or Government of Canada department can provide information to the RCMP relative to a possible federal offense. In the cases relating to sanctions, the referrals are often made by CBSA and our international law enforcement partners such as the Federal Bureau of Investigation or the Immigration and Customs Enforcement Branch, or ICE, in the USA. Specifically, the UN Act, its regulations, and CIMA also requiring anyone in Canada and Canadians abroad to inform the RCMP of information they know pertaining to property that could belong to anyone on a sanctions list. This includes information about transactions or proposed transactions relating to such property. When the RCMP receives information, it is assessed to determine whether it is within the law enforcement mandate, and if so, what the appropriate next steps may be. Within the national security arena, the RCMP utilizes a prioritization rating of operational files, or PROOF. It was designed to assess information to determine the next steps, the level of risk that may be incurred as a result of the information, and the level of governance that my outfit, my shop, Federal Police and Criminal Operations, National Security, must exercise. When it is a medium or a high risk, that is when our national security governance mechanism comes into play. Matters that receive a low priority or low proofing get referred to other government departments, such as potentially the CSIS, or to the police of jurisdiction. And that all depends on whether it relates directly to a national security criminal offense or not, or another federal statute. The RCMP relies on the Export Controls Division at GAC, Global Affairs Canada, to determine whether a good or technology is controlled under the export control list. Such determinations are essential to investigations and even more essential to a successful prosecution. Once the RCMP determines that it may commence an investigation and what degree of oversight is required, the mechanics of police work kick in. Federal statute investigations are complex, resource-intensive, and onerous. It's very likely that they will meet the definition of what we call a major project. And if that's the case, then we have a prioritization process for major projects. Many of the major project investigative techniques require approval from national headquarters. So to go off script here, when an operational plan is written that includes such a investigative technique, it will come into the headquarters from the divisional level, where my shop will assess it. We'll move it up the line to the Assistant Commissioner for Federal Policing Operations for approval. At the same time, we have what we call a project prioritization scale. What we're looking for within that is the effective use of our major case management techniques to enhance the likelihood of successful prosecution. The prioritization model results in the Federal Policing Operations Information Management personnel looking at all of the factors surrounding that project and assigning to it some scores. There's then a standing committee within national headquarters of personnel such as myself, chaired by the Director General of Federal Police Criminal Operations, that will assign a tier to that file. The Tier 1 is the highest priority files, and they require significant oversight from Federal Police and Criminal Operations. Tier 2 requires less. Tier 3 won't require any sort of NHQ oversight. I've spoken about the fact that this isn't a stop-start process. The investigators are still building a case, gathering evidence, submitting their operational plans, which are being assessed. And once the investigation is approved and the specialized investigative techniques are put into play and it's deemed a priority 1 or priority 2, that's really when the police work starts. And we can't do that without good partnerships, particularly with our Public Prosecution Service of Canada personnel. Many of our integrated national security enforcement teams have embedded Crown prosecutors with them, which is very, very helpful. And not that we're led by the Crown, but it's nice to have that specialized legal background to help us maneuver through some of the trickier areas of the law. And of course, at the end of the day, the Attorney General has to give consent to many charges being laid pursuant to the Anti-Terrorism Act or some of these acts that we have here, CIMA in particular. We have two investigations that I'll speak to briefly that have been successful in these areas. The first is the Yadagari case, and it was essentially, I spoke to partnerships earlier, it was a referral from the U.S. Immigration and Customs Enforcement, and it came by way of CBSA. It resulted in a project being called OWatch in 2009. And it determined that a male named Mahmoud Yadagari, who was an Iranian-born Canadian citizen, was using a front country to procure pressure transducers, or a pressure sensor, from manufacturers and distributors in the USA and Canada in contravention of the Iran regulations of the UN Act, the Export and Imports Permit Act, Canada Customs Act, the Canadian Nuclear Safety and Control Act, and the Criminal Code of Canada. These transducers were to be exported from Canada to Dubai, but intended for use in Iran's nuclear program. The investigation was an onerous one, as I spoke of before. It gathered evidence to show that Mr. Yadagari had falsified export documents, removed identifying labels on the transducers, received large amounts of cash deposits and international money transfers, had contacted over 118 companies and exchanged more than 2,000 emails with suppliers, manufacturers, both domestically and abroad. Again, this case was complex, resource-intensive, and depended upon the cooperation of our other governmental partners. At the conclusion, there were sufficient grounds to conduct the first-ever Canadian prosecution of charges pursuant to the United Nations Iran regulations and the Canadian Nuclear Safety Control Act. And that resulted in a guilty finding and under the acts previously mentioned, and Mr. Yadagari was sentenced to a total of 4 years and 3 months in prison. In another case, CBSA intercepted a shipment of highly specialized rubber rings in May 2011 that had dual uses, both for Alberta's oil fields, or oil fields generally, and in a nuclear program. In a joint investigation, the RCMP and CBSA investigated Lee Specialties Limited, a company in Red Deer, Alberta, that manufactures oil field equipment. The investigation determined that, in fact, Lee Specialties was exporting the rubber rings as a prohibited good in contravention of the United Nations Act on Iran Regulations, CIMA, and the Canadian Customs Act. And on April 14, 2014, Lee Specialties Limited pleaded guilty to charges under CIMA and was fined $90,000. This was the first successful charge in prosecution in Canada under the CIMA. Investigations into transgressions of the above discussed and other federal acts require a sound and in-depth knowledge of Canada's export control lists, intersecting domestic and international legislation, close collaboration with domestic and international partners, and investigative expertise in what is a constantly evolving arena. The investigation of these statutes is dependent upon a number of determinations. Whether a good is allowed to be exported is a highly complex and time-consuming process that requires assistance from experts outside of the RCMP. Once major project investigations do commence, they are lengthy, resource-intensive, and require dedicated personnel across a spectrum of agencies and departments to work cooperatively to enhance the likelihood of a successful prosecution. In conclusion, I would like to highlight that as Canada's National Police Force, the RCMP has a broad mandate to prevent, disrupt, and investigate some of the most serious criminal and federal statute violation activity in Canada and abroad, and that it relies upon its domestic and international partners to safeguard Canada, Canadians, and our allies. Thank you.
Thank you, Mr. Nordstrom. And I want to go now to Mrs. Ring, Madam Ring, for her remarks, and then we'll go right to questions after that.
Great. Good afternoon. Thank you for inviting me here today to discuss the Office of the Superintendent of Financial Institutions' role as it relates to the Special Economic Measures Act, CEMA, and the Freezing Assets of Corrupt Officials Act, FOA. The Office of the Superintendent of Financial Institutions, or OSFI as we're known, is Canada's primary prudential regulator and supervisor of federally regulated financial institutions such as banks, insurance and trust companies, and private pension plans. We promote financial stability by keeping a close eye on the solvency, liquidity, safety, and soundness of federally regulated financial institutions. OSFI, like other major financial regulators, is a member of the Basel Committee on Banking Supervision and the International Association of Insurance Supervisors. We subscribe to these bodies' core principles of prudential supervision, which are recognized by the Financial Action Task Force, or FATF, the organization that sets international anti-money laundering and anti-terrorist financing standards. OSFI's expectations are outlined in guidance that forms the basis of its anti-money laundering assessment program. This program focuses on whether an institution has put in place the appropriate risk management systems and controls to detect and deter money laundering and terrorist financing. Although OSFI does not have a legislative role under the CIMA or the FACFOA, it assesses the quality of controls in place at federally regulated financial institutions to comply with criminal anti-terrorist sanctions under the UN Act and the Criminal Code. This work is included as a module in our general AML/ATF assessment program. We leverage this work to address similar controls that are required to comply with CIMA and FACFOA and require institutions to address weaknesses in this regard. While OSFI is permitted to share information or share certain information with FINTRAC, OSFI does not share information with those responsible for enforcing CIMA or FACFOA. To help financial institutions, OSFI has published an overview of AML/ATF sanctions and an instruction guide on its website. Most federally regulated financial institutions subscribe to OSFI's email notification system alerting them to changes. This, in turn, enables them to implement searching, blocking, freezing, and reporting obligations set out in regulations. OSFI's AML and compliance group also acts as OSFI's liaison with other Canadian and international stakeholders on financial crime-related matters. OSFI, for example, is a member of the Advisory Committee on Money Laundering and Terrorist Financing, which meets semi-annually under the leadership of the Department of Finance. Today I've touched briefly on OSFI's role. It relates to the area of study by this committee, and I'd be pleased to answer any questions that you have in due course.
Thank you very much, and I'll now go to Mr. Kent.
And thank you both for attending this meeting. I wonder, did you attend the entire hour of the previous witnesses' testimony from Foreign Affairs? And I want to speak to the case of Vitaly Malkin, who's an individual. I won't go through all of the list of alleged and credible evidence of wrongdoing. But here's a case, and Superintendent, you spoke to the interdepartmental partnerships, but I think the Vitaly Malkin case over more than 2 decades is a good example of interdepartmental dysfunction to a certain extent, because we see a case where immigration regularly, quite frequently, refused his entry to Canada, eventually blocked his application for Canadian citizenship, overturned by his access to Canada overturned by a judge. Russian foreign ministers intervened with the Foreign Affairs Department of Canada on his behalf. CSIS has a file, we understand, which cannot be released because of its sensitive contents. We know that Mr. Malkin, although eventually allowed entry, if not citizenship, has brought tens of millions of dollars into Canada and has acquired real estate properties well known to, I assume, you as well as other authorities, certainly well known in my home city of Toronto, and investments. I'm wondering if either of your corners of government are aware of any other cases where the international criminal activity of a person, supported by credible and abundant evidence, was known to these government agencies, your agencies, and if these individuals, other individuals, were able to bring their assets into this country as well as Mr. Malkin?
Thank you for the question, sir. I have no knowledge of the specifics of that case.
In general terms?
In general terms. But if we did have an investigation on that, I would not be able to confirm or deny its existence or speak to it. I would say that there is a great deal of intelligence in these financial areas. But as I spoke to earlier in my opening remarks, converting that into evidence that's usable for a criminal court is always the key. And it's not an easy task, and we call it the intelligence to evidence conundrum. So, without getting into specifics further, I think I'll leave that at that.
Would you agree with the previous witnesses that there are gaps in the interruption of known criminals bringing ill-gotten gains of substantial amounts into Canada?
Well, I've been warned about making opinions, so therefore I won't make one. Thank you, sir.
All right. And the Office of the Financial...
I cannot comment on this, as this particular matter is beyond the scope of OSFI's mandate.
Okay. I'd like to move on to the Freezing Assets of Corrupt Foreign Officials Act. And as we've discussed here today, it applies to politically exposed foreign persons, and there's quite a long list of individuals. It doesn't apply to the owners of foreign banks. It doesn't apply to state security officials, and again, there's abundant evidence from Russia of prison officials, of security officials, accumulating great wealth far beyond even their lifetime anticipated payroll as civil servants, and that these individuals do move money around the world to other countries, safe havens, if you will. And I'm just wondering, how would the Freezing Assets of Corrupt Foreign Officials Act apply to someone who isn't listed as a politically exposed foreign person? In other words, someone who is exceptionally corrupt, and we know that, again, from credible evidence from Russia, for example, that there are a good number of these individuals who wouldn't fit these definitions, who could potentially, as Mr. Malkin did, move tens of millions of dollars into Canada. Either of you.
Well, I could take a first piece of that. So you're talking about something outside of FACFOA.
Well, if I could ask both of you, have either of you read Red Notice by Bill Broder?
No.
If I could suggest that maybe it would be good bedside reading in the weeks and months ahead as we come to advocate for the Magnitsky Act to fill in some of the gaps that exist between these current two pieces of legislation. But I'm sorry for interrupting.
It's not a problem at all, sir. Thank you. So if you are talking about prosecutions outside or investigations outside of FACFOA,
yes,
that's an entirely different sort of arena than what we're talking about here.
Yes.
And there are some areas, and I listened to the discussion before, but I'm not entirely sure about an answer as to what could be done. If you're talking about the seizure of foreign assets, or of assets of a person such as that who have come to Canada.
And the denial of their entry into Canada.
I would think, and this is me going out on a limb and speculating, there's something in there that could be done pursuant to the Customs Act. I was looking briefly at the Proceeds of Crime and Terrorist Financing Act just on my BlackBerry when I was listening before, and I see that there are powers to seize currency that's moved into Canada by a variety of means. So I don't want to get nailed down into the specifics and give you a yes, no, but just from my perspective, maybe there is something that can be done outside of FACFOA.
Okay, thank you. And now we'll go to Mr. Sidhu, please.
Thank you, Chair. Thank you for coming out today. In your opening remarks, you did touch about the mechanism working with international and internal agencies. But I was wondering, when it comes down to resources, does our CMP set aside or dedicate enough resources, human and financially, to enforce these orders?
Well, thank you for that question, Mr. Sidhu. There are, as I spoke to in my opening remarks, the prioritization process is involved. The RCMP has limited resources, and these processes have been developed to ensure that we focus them on the right files at the right time and to leverage the help of our partners to ensure that justice is done for the highest priority files. I believe that we do have the resources required across the law enforcement community to address the high priority files.
Just to follow up here, what's the success rate when you start investigating a certain amount of people? What do you think is the success rate? What's your experience?
Well, sir, on that, thank you for that question. I've always said we're Canadian and we measure success by putting a prosecution to the Crown Counsel, and then we wash our hands of it. If we've done our job pursuant to the justice system, we're quite happy.
Thank you.
Okay, thank you. Just so I can be clear, in your comments you said on, we were relating to a couple of the cases. It says here, on April 14, 2014, Lee Specialties Limited pleaded guilty to charges under CIMA and was fined $90,000. This was the first successful charge and conviction in Canada pursuant to CIMA. So am I led to believe and understand that this is the first one since the legislation came into effect in 2010?
That is correct, sir.
Okay.
1992.
Sorry, 92.
92. Yes.
So this will be the first since 1992.
That's correct, sir.
Okay. I don't want to speculate or to suggest, but it would seem to me that it's a long time never to have a conviction under a piece of legislation. Would almost suggest that it hasn't got a lot of strength to it, and or, as the question that Mr. Sidhu put to you, maybe the RCMP has no resources. Or maybe, as Mr. Kent is suggesting, there's some gaps in the legislation. I mean, it all leads you to wonder. I mean, this is supposed to be put in place, in fact, to deal with these kinds of sanctions, and it's only been successful once since '92. Do you have any particular view of why that is?
No, not a view, sir. I will say that we work with the legislation that's been passed by Parliament, and again, we try and prioritize to address the highest priority projects and crimes, predominantly to prevent the loss of life and investigate terrorist acts that could lead to the loss of life, or other such items that do receive a higher priority rating.
Okay. Madame Lavadière.
Merci beaucoup, Monsieur.
Thank you, Mr. Chairman. I think the question you've just put is a very interesting one, very relevant.
I mean, some people wonder whether or not there are gaps. One recent example is a straight group who exported arms to South Sudan, even though there are sanctions, and sanctions that apply to Canadian abroad and Canadian companies applying abroad. We learn of straight group activities through the media. So were you aware of that? Were you already monitoring or investigating the situation? And if the group is prosecuted or whatever, what are the potential penalties for that group?
Thank you for the question, madam. Again, I must say that I can neither confirm nor deny that there is an investigation into the straight group underway. And as far as penalties go, I would never seek to fetter the investigative team's ambit and would let them go where the evidence takes them to arrive at the appropriate charges.
Merci, Monsieur le Président. Ma question suivante.
Thank you, Mr. Chairman. My next question is for Ms. Ring. In your 2010 guide produced by OSFI, you say that OSFI does not intend to amend the guide as legislation is amended. Your site also states that information on sanctions against Russia date back to 2014, when the sanctions and regulations were amended in 2016 and 2015. Why is that?
Could I just ask for the latter part of the question to be repeated?
Okay. I'll repeat it in English. So first, it's two questions. Your guide for financial institution, your 2010 guide, says that you will not modify the guide when the laws themselves and the regulations are modified. So I want to know why you've decided that you wouldn't adapt the guide to further modifications to the laws and the regulations. And on your website also, all the information about sanctions against Russia are date from 2014, even though there's been changes to those sanctions after 2014. So I'm trying to understand why you don't want to modify the guide and why isn't the website updated. Thank you.
So the process within OSFI with respect to issuance of guides and guidance is at a point of time. OSFI does issue notices on our website when there are changes to regulations, to the UN regulations or CIMA and PACFOA, as they are updated. So that is the process with respect to notifying the industry, is through our website when changes are implemented.
D'accord, mais dans le cas de...
But in the case of Russia, I still don't understand. You have instructions and information on the site, and that site hasn't been amended. It would be interesting for the committee to see your guide so that we can gain a better understanding. We know that it's important to many Canadians. For example, with regard to sanctions against Iran, many people from the Iranian community in Canada and students had their bank accounts closed or blocked. So it would be interesting to see how the information is provided to financial institution, and it would be useful to see your guide. On your website, do you have a complete list of all people and organizations targeted by Canadian sanctions? And is that list easy to consult?
Great. Thank you for the question. So OSFI does not maintain a consolidated list. It's OSFI's expectation that our financial institutions go to the direct source for the listings. We can provide the committee with a copy of our instruction guide. We can leave that with the clerk today.
Thank you. And Mr. Frascatos, please.
Thank you very much, Chair. Just to follow up on that, I actually think it's a very good question that my colleague asked. What's the rationale? What's the rationale for not providing a clear list of names, a clear list of consolidated individuals who have been designated under Canada's sanctions statute? That would go a long way, I think, to helping financial institutions across the country in determining who they should be on the lookout for?
Okay. Well, thank you for the question. The rationale is related to OSFI's mandate. OSFI does not have a legislated role with respect to CIMA or FACFOA.
Would you be able to comment on, I understand that's not that's not within the purview of OSFI, but why was that not included? Why is that not under your purview, basically? It seems to me to be a huge gap.
I cannot comment on that particular gap. I would suggest that the committee ask the policymakers or Parliament as to why this is not included in OSFI's mandate.
When OSFI is engaging with financial institutions, are you hearing from them that this would be helpful? Because I think it would be quite cumbersome on those, it would present a huge burden on those organizations to carry out the screening obligation on their own, and they ought to, but we should be providing mechanisms to assist in that process. Mm-hmm. Are you hearing that kind of feedback?
I can't comment on comments or concerns from the industry. I would suggest that the committee may want to seek input from the industry itself to speak to these matters.
Okay. The chair raised a very interesting point as far as the success of CIMA and the April 14th case. Even in that case, Lee Specialties Limited pleaded guilty. So even there, I mean, if they didn't plead guilty, perhaps we wouldn't have any success rate in terms of convictions. Sergeant, or Superintendent rather, Nordstrom, I know that you can't comment in terms of opinions, but can you sketch out, with your experience in mind here, can you sketch out what an effective piece of sanctions legislation might look like that would increase increase convictions? What would you, if it's up to you to decide what an effective piece of legislation looks like, what should be in that legislation? What kind of provisions to ensure greater success?
Well, again, as I've said before, Parliament has passed a piece of legislation here, and we, the police, working with our partners, we simply try when we can to enforce it. I won't speak to whether it's got gaps or whether there could be more. I simply would say that, like the criminal code, which is the one that we predominantly use, it all is a challenge to find evidence that can be used in court.
So you're not willing to comment in terms of specific drawbacks that exist within the legislation that are preventing the RCMP from carrying out investigations that lead to a higher conviction rate? What is it within CIMA that is preventing that from moving forward? That's what I'm most concerned with.
Sir, thank you for the question. I don't see anything in CIMA that prevents us from moving forward on an investigation that's deemed a priority to move forward upon.
Okay. Yeah. Thank you very much. That's all I have. I don't think I'll get, and I know I'm putting you in a difficult position, but when we see that, they pleaded guilty, it's our only case of a successful conviction, I think there's some questions that need to be asked. So that's why I am pushing. But and I understand your position, but it's about coming up with a strong piece of legislation here, and it is on the books. But what gaps potentially exist that we could rectify? And I suppose I'll have to follow up with another witness at another time and this will be a long study, so there'll be many opportunities for that. Thank you very much.
Thank you, Mr. Levitt.
So, Mr. Mayor, I was wondering if you can take us through a little bit more the disclosure and other compliance obligations that have been imposed on financial institutions by our sanctions regime. We heard that, I suppose, that it's primarily proactive because there's not even some sort of a list that's able to, give them an insight into who may be on there. The onus is on them. How difficult is it for a financial institution to determine whether it's in possession or control of property designated individually or to an entity that may be subject to the sanctions regime? And what about transactions monitoring and screening processes? What financial institutions are using in that area? Can you give us a little more kind of insight into the flow of information and again, back to my colleague's point about, is this is this system the reason that we're seeing so little conviction and success at the other end?
So thank you for your question. I can speak to the work that OSFI does specifically, questions pertaining to the difficulty with respect to a financial institution's ability to search listed individuals and entities. I would suggest the committee meet with the industry to ask those specific questions. When, as part of our supervisory work in the OSFI looks at a variety of components. One of those is with respect to the scope of the sanctions work, and that's an institution's ability to meet their obligations to search individuals. You mentioned transaction monitoring. We also look at an institution's ability to search transactions and meet their legislative obligations.
Thank you. Superintendent Nordstrom, we hear as we've seen here and abroad, sometimes lists like these contain errors, and we've certainly heard situations with things like no-fly lists where people with a similar name end up getting caught in the process. Has there been individuals or entities that have inadvertently been caught by these sanctions that you hear about on your end in trying to prosecute? Is there any margin for error that's been inherent in this system?
None to my knowledge. I look to my colleague here. Who says that very few times do we get mistaken identity issues such as you've just raised.
Okay, thank you.
Thanks. Thank you. Mr. Kamiak, please.
Thank you all for coming in today. So I'm going to start with you, Madam Ring. Just a question here. So what happens if a credit union or a quasi-bank like ATB Financial, which is not directly regulated by OSFI, has questionable transactions being made? Are they receiving training as well, or do they get any oversight from you, any assistance in tracking potentially illegal transactions?
Okay, thank you for the question. The entities that you mentioned do not fall within the scope of OSFI's mandate. Credit unions fall under the scope of FINTRAC, so I would suggest the committee may want to ask the question of FINTRAC.
Okay. And what about ATB Financial? It's a quasi-bank in Alberta, owned wholly by the Alberta government.
If it is it registered as a money service business?
It has its own act.
It has its own act. It may fall under provincial regulation.
Okay.
And
so
outside of OSFI.
So is FINTRAC effective then?
I'm not in a position to comment on the effectiveness of another agency.
But you do interact with them?
We do interact.
So do you find it effective then? You're saying that they do cover credit unions. How effective is that? Do you know?
I do not know.
Okay. So maybe we'll just switch to you, sir, Superintendent. Thank you for coming in. I just want to start with the question about investigations. I'm not going to ask specifics about them. What I did want to know is how many times are you aware of that you've received information from United States sources using their Magnitsky Act to either inform, start off investigations in Canada?
I have no knowledge of any, but we'll ask Sergeant Hart. That he's aware of.
None that you're aware of? Okay, is it possible that RCMP has received it through a different office, that this information is passed on, or is it just not information that...
Well, it would go to Sergeant Hart.
Could you say that again, sir? I can't quite hear you.
So I'm just wondering whether in situations where in the United States they've passed the Magnitsky Act, where they do collect information and they do cite individuals, is any of that information ever received by your agency at some point? To inform investigations, to receive assistance, to kick off an investigation in Canada.
But in relation to this Magnitsky Act that you're talking about, not that I'm aware of.
Not that you're aware of. Okay, so, and I had a question, Superintendent, in your comments you had something here about UN Act, its regulations CML require anyone in Canada and Canadians abroad to inform the RCMP of information pertaining to property that could belong to anyone on a sanctions list. is that sanctions list you're referring to a public document that anybody can have access to?
That's right out of the Act, out of the SEMA and the FACFOA.
Okay, so it would be right there. But I mean, is it a document that's easily accessible for the public? If all Canadian institutions and Canadians are responsible to comply with the Act, it should be something that's readily available, that's updated on a pretty consistent basis.
I don't know anything about who would update that, and I don't know how accessible it is to Canadians.
Okay. So then how would a Canadian who is looking to understand, and again, in the case of, I think one of my colleagues mentioned a company in Alberta that admitted fault and admitted that they had indeed made a transaction that was illegal, how would they have then figured out that they were not supposed to be selling those particular items to an Iranian company?
Okay, well, to answer your first question, my colleague Sergeant Hart informs me that Global Affairs Canada administers that act, so I would defer that first question to them. The second question, I'm sorry, I was a little distracted trying to get an answer to the first question. If you could just repeat
So
it.
how would a company, in the cases Lee Specialties Limited specifically, pleaded guilty? So how were they supposed to figure out that they weren't supposed to be selling these particular goods to Iran if they can't find that information readily available online somewhere? Well, all the sanctions information would be easily listed, so a Canadian company or individual would know these groups are off limits, you're not supposed to transact or do any type of transactions with.
Okay, thank you, sir. I defer that again to whomever compiles the export control list. I believe it's Global Affairs Canada. Yes.
Mr. Hart, do you have any comments on that, or?
It is available online.
Online?
Yes,
okay.
it is.
Can you talk a little bit more then about the interaction you have with CBSA? Because in these cases, it seems like the CBSA plays a really big role in both identifying investigations and seizing property right at the border at some point that is in the country illegally or attempting to be entered into the country illegally. So what is your interaction with the CBSA? Like, is it a working group? Is it a task force? Is it like how seamless is this integration with CBSA?
Well, I'm just going to speak from experience here. CBSA performs a very valuable role, a frontline role at the ports and ports of entry and exit in the ports, seaports, airports, etc. Their frontline personnel are skilled. This is particularly when it comes to this sort of area, this counterproliferation area and these asset areas pursuant to sanctions, it's pretty specialized work. I was fortunate enough to be posted abroad in London as a liaison officer for 3 years, and I worked with the London Met Police fellows that did counterproliferation, and they did it with the UK Border Agency. I would describe it as a similar situation to what we have in Canada, where the UKBA personnel had the very specialized knowledge and the sort of thinking and the intelligence behind what to target to get to these prescribed goods. You know, without speaking too highly of CBSA, I would just say that they're very similar here.
Okay. Mr. Chair, do I have some more time?
No, you don't. So I will go to Mr. Miller, please. Thanks, Tom. You'll get your chance, Alan. Mr. Miller, please.
Thank you. Just, excuse me, just a quick commentary to what my colleagues raised about the success or non of SEMA. It seems to me, as I've read SEMA, that the success of the legislative regime doesn't necessarily depend on how many prosecutions. I mean, I think the role that you play is one of prevention and enforcing the fact that there may be export and import restrictions that are imposed upon a country. And a lot of that has to do with information sharing and actual work at the border and preventing stuff from going to the place where it shouldn't be going and then in turn coming in as part of enforcing the regime. Obviously, it's surprising that one prosecution only and successful conviction. And then when we're talking about assets, they may be ill-gotten, they may be properly gotten, or whatever the expression is. The thing that interests me with you is sort of the life cycle of what you do in freezing an asset. So in my mind, that's freezing a bank account, seizing a house, freezing a security, or preventing an export. How difficult are any of those four things to do once you get the green light? And how long does it take typically once, again, you have the green light?
Now, are we talking under FACFOA or SEMA?
Any one you choose to discuss.
Any federal statute?
FACFOA, let's say.
FACFOA. I'm not aware of any asset seizures under FACFOA. Asset forfeitures. These are, without getting into the specifics of it, we have to work in concert with our partners to gather the evidence and determine what we can and can't do. And quite often there are processes in play that are outside of our control. For example, Public Prosecution Service, the International Assistance Group of Department of Justice, when we have to get letters rogatory or MLATs exercised in order to satisfy a judge that the asset or other seizure or forfeiture is a valid one. I can speak to a process that is underway right now, hypothetically, where it is completely outside of our control with respect to what to do with the seized assets. None of this is easy. It's a very complex piece of the law, and as I said earlier, that's why we have the partnership with the Public Prosecution Service of Canada right from the start of an investigation. Apologize if I can't fully answer your question.
No, I guess in any of the legislative regimes that you have authority to act under, how difficult is it? A simple thing like freezing a bank account. What is sort of the life cycle of freezing a bank account?
Well, freezing a bank account is really outside of our control. It requires judicial authorization to do. Getting the records for a bank account is within our control, or we would seek a production order from a judge by putting an information to obtain or an affidavit before the judge. I would ask if my partner, Sergeant Hart, here has any further information that he can impart to you on that.
There are times when the bank, when identifying an individual who's listed in any of these regulations, may take their own action and stop a transaction and advise the police. But the boss is right. It takes a heck of a lot of paperwork to freeze assets.
And it's outside of our control.
And when the threat exists, obviously this has to be done in a somewhat confidential situation to prevent the person from moving in a very sort of fluid transactional world, the money out of the country or some other fashion of obscuring the asset in the effort to avoid detection and freezing. I guess if there's a frustration related to the time period, that's a real sort of hole in the implementation of the legislation in my mind.
Well, I wouldn't describe it as anything to do with the legislation. I would just say that these types of realities are what we face every day in trying to be timely in our enforcement actions.
Thank you. That's it.
Okay. Thank you very much. Madame Lavidière has got a short question, and then I got a short one myself, and I think we'll wrap it up.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chairman. Superintendent, you said a number of times that the investigations were being carried out according to an order of priority, and that, of course, is natural. I was wondering how those priorities are established. There has been only one prosecution in the past 25 years. Should we therefore understand that to mean that prosecutions under CIMA are not considered priorities? Thank you.
My opening remarks, it really is based upon a totality of the facts, and our Office of Information Management that assesses all of the facts assigns ratings pursuant to a benchmark of definitions. And when the standing committee that I referenced sits to meet, we're provided with, prior to that meeting, we're provided with the operational plan itself and the scoring matrix that we can look at. We can read it, we can put our minds to what all is entailed in that investigation, and then determine whether it's a Tier 1, Tier 2, or Tier 3 investigation. In my experience, in the past over a year and a half in my current role, the highest priority files are our Anti-Terrorist Act investigations, and they really are about potentially saving lives and getting to people that could perpetrate acts that will make the front page of the news. And that is our job, and that's why we take it very seriously. Not to say that CIMA or the other acts do not have a role to play, But as the other member said earlier, it could potentially be in the disruption, which is part of our mandate as well, to prevent crime, where the answer lies rather than the prosecution. I think, in summary, prioritization of files the way it is right now works, and we're getting our resources allocated to the right files.
Okay. All right, colleagues, I want to thank Superintendent Nordstrom and Sergeant Hart and Madame Ring for a very good presentation. One thing to remind the committee, we will be inviting the Canadian Banking Association to make a presentation to our committee. We will be inviting the border customs folks to come and talk to us a little bit about the whole issue of prevention vis-a-vis permits and how that works through the Economic Measures Act. So I just want to make this comment. It's the beginning of a very important and complex file. This legislation has many components to it, and so I want to thank the witnesses for doing their very best to sort of lay it all out for us from a legal perspective, both financially and through the RCMP. So on behalf of the committee, I want to thank you for that. And we do understand the sensitivity of discussing ongoing investigations. And so I'm sure the committee is aware that we will confront that pretty much all through this process as we work our way through it. And so I want to encourage all of you to sort of keep that in mind. Again, on behalf of the committee, thank you very much, and I will see the committee back here on Wednesday. Meeting adjourned.